afternoon, everyone, and Happy New Year. Thank you for joining us for January's Ask the Attorney. We've been trying to solicit questions ahead of the meeting, and for this month we did have a couple submissions, but hopefully that will build over time. We're just trying to make sure that we broadcast this event as widely as possible, and we'd love to have as much agent participation as possible. We're really, trying to tailor these sort of a type of lunch and learn for you guys, so that issues that you have come up, actual closings that you're in the middle of, or you anticipate listing something in the near future, you have a question. Would love to get those sorts of real world dilemmas that you guys out there in agent world are dealing with. Please, in the future, we're going to try and do this the first Wednesday of every month over the course of the coming year. And we'll be doing it at noon on that first Wednesday of the month. Unless, there's some kind of conflict or holiday or something that comes up, but otherwise that's what we're going to try and maintain as our normal schedule. So we'll go ahead and lead off with a couple of the questions that were submitted online. So the first one was, hello Ganek team, I have a property with down payment assistance lien positions on it that I am looking to understand the legal terms on how to, number one, eliminate the lien, and I'm emphasizing the word lien deliberately, and number two, have a buyer slash investor assume the mortgage and payments of, to allow that investor to express ownership, control of the home in exchange for a cash offer. So there's a number of things in this question that raise red flags for me, unfortunately for the sender. I hate to give you the answer you didn't want to hear. But first of all, down payment assistance programs are designed specifically to help people owner occupy their property. It's not meant for investors. It's meant for, oftentimes first time home buyers, but I guess it doesn't have to be first time home buyer. We'd have to look at the different programs. I'm proud to say that Ganek, we have been a pioneer, a leader in the world of down payment assistance. When those programs first came into being, the founder of our firm, Jeff Ganek, was one of the very first firms to sign up. We have been approved to close down payment assistance transactions from day one. That's something I'm very proud of, and something that we have continued. Back in the day, we used to deal with an organization called IRFA, which I believe was the Urban Rehabilitation Finance Authority. I believe that's what that stood for. And over the years, the administration of those programs has moved around, and those programs have expanded. We now have a number of different programs, and the requirements are different for each of them. They're not all administered, but a lot of them are administered by an organization now that has been in existence for a number of years called Invest Atlanta. Invest Atlanta does a number of things, but one of the things that it's in charge of is administering down payment assistance programs for the city of Atlanta. But we also have some that come from DeKalb County. There have been lately some sort of more private sounding or quasi-private. But again, the goal of all of these programs is to assist homeowners. And that's not home investors. That's for the person who owns the property that also reside in the property. So owner occupied. And there are several loan officers at several different companies that are specialists in this area. And if anybody out there is working with a buyer who's looking to participate in one of these programs, I would behoove you to seek out one of those loan officers who has expertise in this area. They're really valuable programs, and depending on the person, the person who will be buying, you can sometimes qualify for more than one of these down payment assistance, so we can kind of stack them. I literally have closed some where we had maybe $40,000 or more of down payment assistance, like a $25,000 and a $15,000 and a $10,000. And so we closed the first mortgage, and then we closed as many of those down payment assistance programs after it. And in the question, those were referred to as liens. They are not, I mean, they are a lien in a sense, in that they are a mortgage lien. But they are really, when the buyer buys, they sign a note and they also sign a security deed. So it's really a mortgage, and we'll have as many mortgages as we have down payment assistance programs. So the second part of the question was, I have a buyer investor who wants to assume the mortgage, and I assume by that the sender meant assume the existing first mortgage, so the institutional loan. And that can be done, but again, would be unlikely because typically the loan program that is used for the actual primary mortgage, the one where the buyer does make monthly payments of principal and interest and has an escrow account, typically those are they are often an FHA first mortgage. If I believe you can combine down payment assistance with a conventional loan. Conventional loans have a provision that they must be owner occupied for at least 1 year. So you could transfer, you could sell the property. The current owner could, but they would have to pay off all the down payment assistance loans, unless some of them do have a provision that once you've owner occupied the property for 5 years, then that loan is forgiven. So depending on how long the current owner has lived in the property, it's possible that one or more of the down payment assistance loans could go away. But that first mortgage, in order to be assumed, the holder of the mortgage, the servicer of the mortgage, would have to agree to allow it to be assumed. And it wouldn't be it would be very unusual for a loan assumption to happen. Now, FHA loans are assumable, VA loans are assumable, but then you'd still have the down payment assistance, second, third, perhaps even fourth mortgage underneath that you'd still have to get resolved. So part of the question, it's possible. I think it's unlikely. And then there was also a reference at the end for a cash offer. So I think, unfortunately, what the sender of the question was hoping is that we could have something that would be a loan assumption that would not be something that the primary lender would be aware of. And that's sometimes called a wrap. And I guess, there are firms in Atlanta who are willing to close those. I will say that Ganek is not one of them, because we are in the business of representing lenders, and participating in a loan assumption where the primary lender doesn't know the loan is being assumed would be a violation of the due on sale clause or provision in the security deed for the existing first mortgage, the institutional loan. That would be, what we'd have is we'd be having a seller selling a property and presumably selling without paying off their institutional loan. And perhaps also trying to avoid those down payment assistance second or maybe even more junior security deeds. So there's a number of problems that I see in the question, and also would be something that Ganek, if we were asked to help with this transaction, we would politely decline to participate, because we're not going to help a borrower, and we're talking in this case the seller, be in default of their mortgage or mortgages plural. We're not going to jeopardize our relationship with the institutional lender on the first mortgage or our participation in those down payment assistance programs, because again, that's something that's very important to us to continue to participate in those. I know with back to Invest Atlanta, we now have to reapply for approval to be approved to close those every 2 years, and that is quite a laborious process. In fact, now that I think about it, we're in the new year. This is probably the year that we're going to have to reapply. So I will not look forward to that process, but we will do it. because it's a really something that we're very proud of, being involved since the very early days of those programs. My second question was, I am a new agent, so bear with me if it is a dumb question. Does Ganek PC act as holder of Earnest money? And I do not ever decline to answer a question or label a question as a dumb question, because there are no dumb questions. They're only the questions that you don't ask. So Ganek, we are here to be a resource for you, not just me as president of the firm and one of the principals and managing attorneys. I manage a couple different offices for the firm. Our Midtown office is where I'm located. I'm also very heavily involved with our Tucker office. We do perform closings on site at a satellite in Buckhead, and I'm up there some. But really, I've closed in all of our offices, but I'm not the only resource. If you'll go to our website, there's a number of things that you'll find there. So the website is www.ganekpc, Ganek, and then the letter P as in Paul, C as in cat, .com. PC stands for Professional Corporation. That's what we are. So www.ganekpc.com. And on the very opening page, thank you, Todd. When you open that landing page, at the very top, there's a button that says Order Title. And if you click on that button, you can submit a contract to us on the website. There's a few questions that we're going to ask you, and one of them is, in which office do you want to close in? And then which attorney would you like to handle your transaction? So most of us do travel, some more than others, but I have some really long-standing relationships. So if Todd sends me a contract, I've been closing Todd for probably over 20 years. If Todd says, "Hey, I want to close up in Alpharetta," then the day of the closing, I'll get in my car and I'll drive up and I'll meet Todd at our Alpharetta office. So when you go to the website, you can look at the locations page. You can look at the attorneys page, see a headshot of each of us, read a little bit of our bio. Any combination that you want to pick. We'll also ask you to upload your contract. And then there's also another area on the website where you can direct your buyer to that portal, and the buyer can submit their earnest money to us on electronically. So just a couple caveats on that. That is an ACH type transfer, and ACHs are generally not something that is allowed for closings, and that's because by the time we get to the closing table, all deposits that have been made to our escrow account have to be final. And an ACH is not a final transfer. The way ACH works, it's automated clearinghouse. So those funds can be deposited in our account, but unfortunately, for up to 10 business days later, they can be withdrawn by the same party who deposited the money into our account. So they're not a final deposit. And if you want to think of it like writing a check, if you wrote a check to us, we would accept the check, we would deposit the check, but then we'd have to wait on that check to clear. And if that check were to bounce, then we obviously have a problem. So ACH is the same thing. So those can be pulled back. So we require, if your buyer is going to use our online portal, that the closing date be at least 15 business days later. Well, why 15? Because we need the banks to be able to confirm to us that that deposit is now final. So if your closing date is sooner than that, there's another solution, which is send us a contract, and you can also just email it to any one of our attorneys, any one of our staff members. We also have a email address that we all share called info@Ganek. You can submit a contract that way, and there's a bunch of us that are on that distribution list, and it's sort of a race to see who responds to you first. But as soon as we get the contract, we will open the file same day, and usually, in a matter of, maybe an hour or two. And we will then send out a request for buyer and seller information, and that will start explaining some of the process to send a wire to us. We use a portal, another portal. It's all designed to protect the public, protect you, agents, and your clients. We want to make sure that any transfer of money happens the right way, and that the money doesn't end up getting swept into an account and makes its way within an hour or two to Russia or wherever it may, China, wherever it may be going. So certified requires our buyer to log into a portal, and they answer some questions. And the way we communicate is both via cell phone and email. And so there's multiple layers where they identity proof themselves, and then they are provided with our wiring instructions in a secure format. So it's designed to protect the public and you as the agent. Obviously, if you got a buyer and their earnest money or their wire for closing was one of those that got scammed, and the emails that looked like they maybe came from you or coming from the fraudster, you would not want that to happen. So it's important to work with a firm that has these protections in place. And Ganek, we've always tried to be in the forefront of new technology, new systems, and certified certainly does provide a lot of protection. So we're very proud of our affiliation with that. So those were the questions that we had submitted ahead of time. And I see, Todd was kind enough to provide contact information for our website in the chat. If anybody out there has a question that they'd like to ask in the chat, then I would encourage you to do that. And Timothy Dance, who is the marketing director for our law firm, he's going to moderate and will monitor the chat for me, and will let me know if we have any questions there. So on to a little mini presentation that I've got for you guys. And I'm gonna go ahead and share my screen. Let's see if I'm picking the right one. Hopefully so. All right, so now you should be looking at something called Who Needs Title Insurance? So this is a part of a continuing education seminar that I've taught for Palmer House many times before, and for other brokers as well. And I thought today I would just kind of do a little bit of the intro of that, and we'll hope to get this one on the calendar for sometime soon in the next couple months. I know in January, my partner Renee Dillon is teaching our version of the new GAR contracts class, which is both an overview of the changes that have occurred to the to the contract over the ones that are just come out in the new edition that was published effective January 1st. And she also does an overview of just general advice, and answers a lot of questions that attendees have. So we'll be doing that in January. I'll be teaching a class on estate law in February. And that one we're going to have me teaching for a couple hours, PowerPoint. We'll have some handouts, but we'll also have a guest from Chicago Title who's going to help teach. And her name is Ree McCallum. And she will be kind of going through some title claims that happen as a result of estates not being handled properly by the closing attorney. But I thought we could probably do the Who Needs Title Insurance class, which is both about title examination, title commitments, title policies, and also we cover surveys in that class as well. And so today is just a little bit of an excerpt from that. So let me make sure I've got my, all right, there we go. So what is title insurance? It's coverage for future claims and future losses from title defects. Defects are typically created by a past event, usually from before acquiring the property. There's 5 steps to issuing a title policy. Number 1 is the title examination. And through the title examination, we discover defects. Then we eventually issue a commitment or a title binder. A title commitment is something that typically the law firm sends to the lender, but if a buyer were to request a title commitment, we'd be happy to issue one. Then and at least in our firm at Ganek, both the attorney who's handling the transaction and one of our closing coordinators, we work together to address the defects that are revealed by the title examination, the title report. And then ultimately at closing, we issue a title policy. Now for some forms of title policy, we actually have to wait until not just the closing, but until our documents are actually recorded. A good example would be if we were closing a vacant lot, then we would have to wait until our documents have come back from the courthouse before we issue the policy to the buyer and to the lender. All right, so step 1 is the title examination. So first we have a title search. So we're looking at the county land records. So we're looking in deed books, lien books, something that we used to have called the GED, the General Execution Docket. We're looking at other court records. So there may be things that we find in civil action records at the courthouse. We're looking at the tax records. And then all of that gets assembled into a report. And kind of a preview of what we're going to be talking about in February is for my CE seminar is we're also going to sometimes be looking at the probate records. All right, step 2, discover the defects. So we're going to review title report and look for different owners other than what's shown on the contract. And that's always step 1 for us. We look at the contract and we compare it with who our title examiner has come back and told us is the record owner of the property. And unfortunately, we are often finding that those 2 things don't match. And that may be surprising to some of those out there in the audience. But that's because a lot of times, unfortunately, I know my audience is mostly agents, but there's some agents are better than others. And some of the agents out there don't really do their homework and do their due diligence to try and figure out who in fact is the true owner of the property. And that's one of the most important questions because obviously you want your seller to have the ability to sell. So one of the more common examples, that's why I reference probate, is where a contract comes to us and it's in the name of a person who ultimately we find out is acting as the executor of an estate. So let's say it's going to be for their mom's estate. So sometimes we'll get the name of the mom, who is the deceased person on the contract. That's less common than the name of the executor. So let's just say it's the daughter of the mom. So the daughter's name will come over, but if we don't know that the daughter is acting in her capacity as the executor of the estate, we're going to order title from our examiner using the daughter's name. Now, our title examiner can typically figure that out, but we'd rather have them get the best information possible at the front end when we order title. And if our contract says, let's make up a name, Nancy Jones as executor, well, right then we know that we're dealing with an estate. So we'll know that our examiner will see that, and our examiner will know that they not only have to check, we're going to go back up, county land records, court records, tax records, they're also going to have to check probate. That's a whole nother area of the courthouse. So good information on the front end really helps us. So I'm going to stop my screen share for a minute and jump over to a different one. So here is an example of an actual title report of a transaction that I closed not too long ago. or I should say one of the attorneys in my office closed. And so I'm just going to kind of walk you through. This is a title report, but it's actually sent to us in ALTA commitment form. So what is ALTA? In this case, ALTA stands for the American Land Title Association. And the commitment is the form of document that's a sort of uniform looking document that we use when we're sending our title information. Usually that's over to the lender to the transaction. And this has got, a number of things here. So number one is the commitment effective date. And that's, in this case, was November 4th, 2021. But there's a difference between the date that the title was run or the date that the title was certified and the effective date. The effective date is the date that the clerk of the Superior Court for that county has certified the records. So this report may have been run on, let's just make this up, November 14th, even though the effective date is November 4th, because when the report was run and certified to us, the clerk of the court hadn't caught up to that date. There's very few, or maybe zero, clerks of Superior Court in Georgia whose effective date is that day. Usually there's a lag, and that lag is what we call the gap period. So one of the things that title insurance does is we insure the gap. So a buyer and the buyer's lender, if they have one, they're protected from something that might occur within that gap. And the gap actually even widens because we can have an effective date, and it depends on the title insurance company underwriter, but we can, for some underwriters, as long as our effective date is within 30 days of closing, we're okay to proceed. Now, I know at least one underwriter would like to see that gap period decreased to 10 days, but not every underwriter requires that. I don't know if things will change in 2023, but right now, some underwriters allow us to go 30 days out. So if you think about the original gap period, in my example, I said 14th, so there was already a 12-day gap when we received this report. And now I'm allowed to close another 30 days beyond the effective date. So I could close in this example as late as December 4th of 2021. And some underwriters would allow that. So now I'm insuring a 35-day, if my math is right, no, 45-day gap period. So my original 14 days, or sorry, it was 12 days plus another 30 days. So, it's significant. The way we insure the gap is we take affidavits from the seller at closing, and the seller swears a number of things to us under oath, that they haven't taken out any new mortgages, they haven't gotten sued, they have no new liens against them, they haven't filed bankruptcy, they haven't gotten notice of any tax reassessment. So there's a number of things that they're promising in that affidavit. So they're swearing under oath that none of those things have happened. And that's how we're able to ensure that gap period. All right, so scrolling down, we've got policy or policies to be issued. So in this case, from our contract, our proposed insured were Scott A. Moore and Marla Moore. So I can tell from this, right underneath that, we've got our ALTA loan policy. Keep in mind, this is the title report that came to us from our examiner. Proposed insured is left blank because I can tell from this report that when we opened our file, we opened it using a contract sent to us from an agent. And at the time we ordered title, we didn't know at that point who our lender was going to be. So that's why our title examiner left that blank. Now down a little bit further under number 4, we've got the title, according to our examiner, is vested in an LLC, Property Transaction Services LLC. This is another example of where contracts and sellers don't often match. because it's very common for us to receive a contract signed by an individual when in fact their company, their organization is the true owner of the property. So in this case, let's just say our contract was signed by Sam Smith. But when we ran title, it came back property transaction services, and we're going to go, well, that's weird. Fortunately, in this case, I can tell by my check mark, our contract was properly prepared. We did order title from our examiner using Property Transaction Services LLC as our seller. And that's the check mark, because that's the very first thing that I do when I review a title report is check the record owner. We call that, in this case, Property Transaction Services LLC. One of the little code words or abbreviations that we use in the title industry is RTV, Record Title Vests in this case, the LLC. And I compare that to my contract, and I see that it's a match, and that allows me to apply that check mark. So my staff member knows I've checked the RTV, we're good. In this case, the legal description would have come next, but it was a long legal description, so we have to refer to Schedule C. And then we get into, here's some of the, if you'll notice at the top, Schedule B, Section 1, these are listed as the requirements. So we have two things. I'm gonna jump ahead. Requirements and Schedule B, Section 2, these are the exceptions. So I'm mainly focused when I'm reviewing a title report, I'm mainly focused on reviewing the requirements. So agents, you get wind of the fact that, oh, there's a title problem, and a lot of agents, that's as far as they get. Oh, there's a title problem, we're not going to close. Well, we often encounter title problems that we as a law firm are able to clear, with our years and years of experience. Ganek we were formed in 1978, so we are about to celebrate our 45th year. I joined the firm in 99. I've been practicing law since 1995. I'm just one example. I'm not, in fact, the oldest attorney in the firm. We have a real good cross section of ages. We also have staff members who have been with the firm for 20, 25, 30 years. So you've got a very experienced group of lawyers and a really talented and well-trained team. So we're working as a group and we're clearing titles. That's our job. We don't just prepare settlement statements. We don't just get documents signed at the closing table. In my view, our main job is to clear title, to make sure that our buyer, and if the buyer has a loan, that their lender, that they're all getting clear title from us. All right, so under this one, Schedule B, Section 1, here are my list of requirements. So number 1, instruments have to be recorded. Well, that's on every title. If this is a sale, the law firm, we're going to have to prepare, well, it's listed here as a warranty deed. The GAR contract about, 10 years ago, made it standard operating practice in Metro Atlanta, in the state of Georgia, for sellers to sign limited warranty deeds rather than what's listed here as a warranty deed, also known as a general warranty deed. Those are equally insurable with title insurance. It only has to do with what kind of liability the seller has to the buyer after closing. And again, if you have title insurance as a buyer, your first recourse is going to be to make a claim on your title insurance policy rather than go sue your seller and try and get your recovery that way. Under 1 subpart B, our examiner assumes that we're going to have financing. Most of our transactions do, although the last couple of years we've done many more cash transactions. So we had a security deed. In this case, we knew who our buyers were, so it's set up that way. And I left the names in there because this is ultimately became a public record, this transaction. So if you search title under this property address, you're going to find Scott A. Moore and Marla Moore became the owners in late 2021. And here it was listed to be determined because, again, we didn't know at the time we ordered title who our lender was going to be. One of the reasons we send out a request for buyer information is because most times when we open our file, it's opened as if it's going to be a cash closing. And the majority of our transactions are finance. So we want to get the buyer to respond to us quickly. Sometimes they have multiple lenders that they're talking to. We want to figure out which lender are you going to use, and we want to get their information so that when it comes time for us to prepare the title commitment, we know the right information to get that out to the lender, because lenders want to get their title commitments from us as soon as possible. They can't move their file along through their system if they're still waiting on title. So we at Ganek, we try and be as proactive as possible and get that out as fast as we can. I mean, obviously it depends on the closing date, how long we've had our file open. You know, if there are other complications with title, what we tend to do is we'll send out a title commitment that shows the defects that we need to, it will list all of these requirements. And for a lot of lenders, that's all they need, just to know that, you know, Ganek is working on it. Some lenders are a little more particular and they want to see certain things removed from the title commitment as soon as possible. And sometimes we can do that, sometimes we can't, because when you clear title, you're relying on third parties to help you. So in this case, we had under number 2, and pardon my chicken scratch, but you can see, you know, titles get reviewed a number of times before they're approved for closing. So my first thing under 2B was I had a bracket and I wrote need releases. And at Ganek, we always try and we apply for releases for tax liens. Now, in this case, we were fairly confident that the taxes for prior years had already been paid by the last closing attorney. But even so, we will still reach out to the county and ask if we can't get our releases filed of record. This one was a little more complicated. I'll explain why in a second. But I want to go back to 2A. So this is a security deed that we're going to need to pay off. So right above, you can see under, when you first read number 2, payment, cancellation, satisfaction, or release from the following. So the first security deed is our seller's mortgage. So out to the side, I just wrote PAC, pay at closing. So the only thing that's going to prevent us from doing that is if we can't get a payoff, in this case from Silliman Private Lending, LLC. Jay Silliman, we've ordered many payoffs from Jay, so I knew that wasn't going to be a problem. So the heavier pen, that was me. I circled number A and wrote PAC. That's instructions to my closing coordinator. We need to order a payoff. And then you can see next to the letters PAC, my closing coordinator put a check mark. So I know that my closing coordinator obtained that payoff. So now I go back through the title a second or a third time and I go, okay, 2A, we're good. What about 2B? I wrote need releases. Then I later wrote, wait a minute, I have another solution to that problem. And I've also got a solution to 2C. 2C, notice of federal tax lien, recorded at lien book 4265, page 362. So for B and C, where I had written originally need releases, instead I now put a big X mark in that and I wrote underneath OTP. What does that stand for? Owner's Title Policy. We clear more problems for title by getting a copy of our seller's owner's title insurance policy than any other way we clear title. So I'm going to jump ahead once again. We're going to go all the way to my examiner gives me a copy of the current deed for the property. You can see that a seller named Johnny D. Thornton sold the property to my seller, Property Transaction Services LLC, in October of 2020. We ran title in November of 2021 for our closing, which ultimately took place in December of 2021. Knowing that another firm had already touched this property and had dealt with some of the more gnarly issues, which was this property in the back chain had a tax sale, it had a lawsuit disputing ownership between two parties. They had dealt with a lot of issues, which fortunately my firm then did not have to deal with because another law firm had already done a lot of that work. So all we had to do was reach out to the Troy King Law Firm in Marietta. And you can see my note, which was again my note to my closing coordinator, OTP question mark, meaning closing coordinator, I need you to reach out to the Troy King Law Firm and request a copy of their seller's owner's title insurance policy. Now, you may ask, well, why didn't we try and obtain that from our seller? In my experience, most sellers don't know where their title policy is, especially somebody like this seller who is a renovator of property. They're out in the field, they're at the house, working, trying to get the appliances delivered and the cabinets in place and the carpet and all that. And, they don't always have things, right there handy on their cell phone in a saved file. So if we reach out to another law firm, we're going to usually have much better results. If that law firm is still around, if that law firm is in fact a law firm, a Georgia law firm, and not some out-of-state title company that doesn't have business in Georgia anymore, or doesn't have like a number that you can call to get a human being on the phone. So I much prefer dealing with other local Georgia lawyers, people who know how Georgia law works and maintain their files and can easily help a fellow member of the bar when we need assistance. So in this case, the Troy King Law Firm was very helpful. They sent us the owner's title policy, and we were able to go back under requirement 2B and 2C, and I wrote yet another note. Yes, we do have an owner's title policy, and it was written on Chicago title. So in certain scenarios, I would switch my underwriter to be Chicago title. We're an agent for many title insurance companies. We write for Chicago, we write for Stewart Title, we write for First American, we write for Old Republic, we write for Commonwealth, we write for Fidelity. So those are all sort of the big heavy hitters that we encounter a lot. In this case, the issues that we were dealing with, tax FIFAs and a notice of a federal tax lien, I actually didn't have to change underwriters, but in practice, we often do that just to kind of keep our files clean. Under 2C, you will see a note that says pay at closing or bond off, and it's very faint, but ultimately there was a check mark there. So in this case, we had a lien, and it turned out to be our seller. So let me jump forward to that page if you want to see what the lien looked like. So there was our mortgage. This is the one we paid off. And then we had a notice of federal tax lien. Now, you remember from the deed that we saw from the Troy King Law Firm, the seller at his transaction was Johnny Thornton. So here we had Johnny Thornton. So it's the same name as a prior owner, and those are hard for us to clear, because it's not like we can ask our seller, Johnny Thornton, hey, what's the last 4 digits of your social security number? We compare it with this lien and we see our seller says their social is 4512. We look at the lien, it says 2263. All right, it's not a match. The address doesn't match. We would have, if Johnny had been our seller, we would have had Johnny sign an affidavit at closing saying, I am not that Johnny D. Thornton. And we would record that. That way, the next person who runs title on this property, the next title examiner or closing attorney, they can find our affidavit and they don't even raise this as an objection or a requirement. But in this case, we had the seller's owner's title insurance policy, so we could just avoid this. We didn't really even have to research it if we didn't want to. But the owner's policy was enough for us to go by. Then here was the lien that was filed. So it was filed by Chris Shuford, a subcontractor, in the amount of $24,880. And you can see it references the name of the owner, Property Transaction Services, LLC. And there's a reference to a subcontractor. One of the unfortunate things is a subcontractor could have a contract with a general contractor. And if the general contractor doesn't pay the subcontractor, then the property owner is sort of left with this problem, because the property owner is the one whose property the lien is claimed against. So I can't remember how this one got resolved, just off the top of my head. But we either got a payoff and paid it off, or we got permission from probably Chicago Title to insure title relying on a bond to bond off the lien, and that's something that the seller would have to obtain. But just wanted to give you an example of a real title that we closed. So let's go back to my other share. All right, so step one, we talked about this already. Let's go back down. Discover the defects. So that's kind of what we were just going over. Review the title report and look for different owners other than the contract, different legal description than the contract. Now, the contracts don't always have an exhibit legal description. Sometimes they do. Sometimes they have a copy of the deed. Sometimes they have a reference to a deed book and page, which is perfectly fine because we can go on the Clerks Cooperative website and pull a copy of the deed ourselves to compare the legal description. So obviously we want to make sure that what we're closing. I closed something recently where my sellers had bought a property, very expensive part of Buckhead, and they had subdivided their property to create a new lot next door. And on that lot, they built a $3.25 million property. And it was obviously very important to my sellers to know that I was conveying, or they were conveying at closing, the deed for the property next door and not the house that they lived in. So in that case, we found the recorded plat. So it was what looks like a survey, was recorded, and the recording showed the existing property where our sellers resided, and it also showed the new property upon which the new house was built. And they labeled those lots, Lot 1 and Lot 2. So it was very easy for me to create the legal description. So I just referenced Lot 1 of that certain plat of subdivision recorded in plat book blank, page blank. It's a little bit longer than that, but that's what we call a short legal description. Now we can also have what we call a long legal description, which is a meets and bounds. And so that's something where, you have the survey and you describe the property starting at a point, going to another point, going to another point. So obviously a long legal is harder to, compare. So, but we always encourage our buyers to have a survey of the property before they buy. I mean, that would not be the case with a condo, an attached townhouse. You might choose to not do that, but anybody buying a single family residence, certainly anybody buying a commercial property, usually it's going to be a requirement of your lender. But with residential, title insurance does not require the buyer to obtain a survey. and they do get some survey coverage, but it's not as broad. There are defects that have deductibles and caps on liability. So we would certainly encourage buyers, you would rather know what you're buying before you buy it. So if our buyer does elect to obtain, have a survey performed, we will help facilitate that. We have a number of surveyors that we've worked with for many years. And when that survey comes in, that will be just like the title report, where the attorney handling that transaction will review the plat of survey, will mark it up. We will send it to the buyer, and to their, actually, I usually send it to their agent first and let the agent ask questions before we ultimately deliver it to the buyer. A lot of times I'll send it to the agent and say, if you have no questions, please forward to your buyer. We do settlement statements the same way, because we want to get agent input before we kind of release that to the end customer, which is the buyer and the seller. So we're also back to my slide, looking for old open loan deeds. So an open loan deed is any loan, any mortgage that has not been paid off. An old open loan deed would be a prior owner's mortgage that is still showing up in the courthouse records as having not been satisfied. And one of the ways that we get around that is by often obtaining the seller's owner's title insurance policy. Now, it may be that we need to go beyond that, because if we think that open loan deed is possibly really still active, then we want the other law firm, to take the steps necessary to get that open loan paid off. But it's unfortunately a very common problem where loans get paid in full, and lenders, especially out-of-state lenders, don't acknowledge their responsibility, which is to file a cancellation at the courthouse. So again, either we're going to have to obtain the seller's owner's title insurance policy, or we're going to have to reach out to the servicer of that old loan, and we're going to have to obtain a release from them. And that's not like ordering a payoff. Sometimes you can get a payoff in a couple hours, but if you need a lien release, you may be waiting days or even weeks for that document to come over on your email or your fax. We're also looking for liens and judgments, some of which we are going to clear because we can determine that it's not our seller, some of which we're going to determine are our seller, in which case we have more payoffs that we need to order. We're going to look for past due taxes, outstanding water bills. For City of Atlanta, there's a whole other process that we have to follow. We have to order a payoff. We have to pay them a fee to get a water statement. We're going to look for sanitation, handled differently depending on the county. In Fulton County, the sanitation bill is actually a City of Atlanta bill, which is collected by the Fulton County Tax Commissioner's Office. In DeKalb County, the sanitation bill is rolled into the DeKalb County taxes. It's a line item. If our property is part of a homeowners association or a condominium, then we're going to need to order what we call a clearance letter from the management company or from the association directly, depending on how big they are. Smaller associations, we're typically ordering our clearance letter from the treasurer, who may be a volunteer and may not be all that computer savvy and may not have a form that we need filled out. So we have forms, and we'll email it or fax it or whatever it takes to get those privately managed. If there's a management company, then typically we have to go on a website. We have to advance payment for the clearance letter. So one of our closing coordinators will set that up, and then we'll reach out to our seller and ask for the seller to remit payment. We have a number of prompts in our system, a lot of automation that helps us with that. because sellers don't always want to pay for that letter, especially if we're still in like, tail end of due diligence, or, there's some issue that maybe the parties to the transaction know about that the law firm, we haven't been told. So there's sometimes reasons why the seller won't pay for the clearance letter. Other times it's just a seller who's, travels a lot, or is not reading their email, or lazy, or whatever. So sometimes we'll have to get the agent representing the seller involved. We try to avoid that whenever we can. I see that I'm getting close on my time here. So step 3, we issue the title commitment to the, again, most often or not, that's the lender who is wanting that. And a commitment is actually a little bit more than just a title report or title a title, just that, a title report from the examiner. Once it becomes a title commitment, that is a promise to issue an insurance policy. And so we tell, typically, again, it's the lender, that once we clear these requirements, then here's what your title report, your title policy is going to look like. And we're going to eliminate all of the requirements, but we're still going to have certain things that are exceptions to the title policy. And those are things like, we're going to take exception if the property is a condominium. We're going to take an exception to the declaration of condominium, because ownership rights of that condominium are affected by everything that you find in the declaration. So title insurance doesn't cover something that we know about when we issue the policy. If we know about it and we can clear it, we can eliminate it, that's great. But if there are things like a declaration of condominium, that's not something that we're going to clear. That's actually part of the ownership, the part of the rights of owning that condominium are all the rights and obligations that come with being a member of the association. So that's an exception to our policy. The insuring company, in this case, Ganek would be the issuer of the policy, but we're issuing on behalf of, in most of my seminar today, we were referencing Chicago Title. So it would be Chicago Title promising to insure subject to certain requirements, conditions, and exceptions. Many of the requirements, again, get eliminated. So step 4, we talked about in great detail, addressing the defects. So we either resolve or extinguish the defects, or certain defects might ultimately be acceptable to our buyer and to our lender. Buyers usually have a little bit more freedom. Lenders have underwriting guidelines that they have to follow. I think I'm going to stop there since we've only got a minute left. Timothy, I saw a couple things pop up in the chat, but that may have just been you. Do we have any questions from the audience?
Yeah, that's all I was looking for, Mark, if there's any questions.
You were just sort of soliciting those?
Yes, sir.
I'll stay on for a minute or two longer. If anybody in the audience has a question, feel free to type it into the chat.
I'm also checking online right now as well.
So, well, I'll just go back to saying Happy New Year again to everybody who joined us today. Appreciate you joining us. And again, we're going to try and do Ask the Attorney on a monthly basis. So our next one will be the first Wednesday in the month of February. Oh no, that falls on the 1st. So I might move that one to the 8th. Let's see. Well, we'll see. January is ordinarily a pretty slow month, so maybe we can go ahead and do it on the 1st. So we'll begin, circulating that, making everybody aware. Save the date. That will go out from Ganek's marketing team. So again, I want to thank everybody for joining us today, and Timothy for serving as our moderator. I'm not seeing anything new coming into the chat, so I guess we'll sign off since it's 1 o'clock.
As always, thank you, Mark.
All right, thanks, Todd. Thanks, Timothy. Thanks, everybody. Happy New Year.